Welcome, everyone. Welcome to episode 173. In this week's episode, we're going to talk estate planning and steps that you should be taking to make sure that your estate plan is up to date. And if you're new to the show, my goal is to teach you how to save for retirement, how to plan for retirement, and how to invest for retirement, and how to pay less taxes in retirement. So if you want more help on how to do all of this, consider taking my comprehensive retirement planning course, Retirement Readiness Review. It's an online course where I will walk you through all the steps in planning and managing your perfect retirement. To learn more, head over to retirewithryan.com/on-demand. Now, estate planning can be a very complex topic, and I'm very happy this week to be joined by special guest Natalie Perry. And Natalie is here to help us, unpack estate planning. Natalie is a CPA and an attorney who has over 2 decades of experience helping families with complex business succession and estate planning matters. Welcome, Natalie.
Thank you, Ryan.
Yeah, I'm excited to get into this topic. I feel it's something that a lot of clients can overlook, and even other financial advisors really can overlook. So, first off, tell me, what is estate planning?
Yeah, so estate planning is anything from asset titling, and I know we're going to get into this a little bit more, from, should you have a joint owner on your accounts, to more of a full-blown estate plan, which might include a will, potentially a trust, and ought to also include powers of attorney that address incapacity when you're still alive but need someone to make decisions for you. All those processes would be governed by a court if you don't have the documents in place.
Sure. So you mentioned court. So we're talking probate court?
Right. So probate can be when you die or if you're incapacitated. You could have a probate in both situations. If you needed someone to manage your financial assets, because if I go to the bank and I say, oh, my husband's incapacitated, I'm just going to sign his name. Of course,
Sure,
they're not
yeah.
going to let me do that. I need to have a power of attorney that authorizes me to sign my name as his agent. So we definitely want to have the appropriate documents so that the court doesn't have to get involved, which saves a lot of money and time and
Sure.
expense when, there's an issue with administering assets.
Yeah, and if you didn't have, let's say, the right documents, which we'll talk about in a minute, and you did need to go to probate court to get permission to take money, let's say, from your spouse's account, how long can that take someone?
Yeah, it really depends on, I think, on the state you're in and even the county, because like where I am in Chicago, in Cook County, where it's the major metropolitan area, the courts are pretty backed up. So it can take
Oh,
three
sure.
months to even get a
Yeah.
court date before to open an estate when someone dies. So that can be problematic if you don't have access to liquidity in the short
Yeah, I didn't
term.
even think of the
So
court, just the
avoiding
backup of the courts, right? You normally think, oh, I want to go to court. I can go in a couple weeks, but probably not, right?
Yeah, you sometimes on an emergency basis you can get in sooner, but it can really
Yeah.
depend.
So let's go
And
ahead.
then Oh, sorry. And then once the proceeding is open, a probate, that can take a year or even 2 years, sometimes longer to complete the
Sure.
process where a final distribution can be made.
Yeah.
So it can really delay
Yeah, and
things.
I guess it depends on how many family members, right? If family members don't agree in a probate process, or there's creditors that don't agree, that could drag things out even further, right?
Yes, you hit the nail on the head there for sure. If we've got to get multiple signatures and it's hard to reach people, or like you said, they don't agree or they don't want to consent to what was done, then we could be in court even
Yeah.
longer.
So what are those documents that I guess would say everybody should have, or are kind of like the foundation of an estate plan?
Well, definitely a will. So a will is required in order to transfer assets to your intended beneficiaries. And I think some people tend to believe that under state law, everything would go to their
Sure.
spouse. And that may be true, but it might depend on the state you live in. If you have children, they're often going to get a portion of someone's estate, even if they're minors, which can add some
Oh, okay.
complexity.
Really?
So you definitely need a will, powers of attorney for property and health care, and sometimes a living will, depending on the state you're in. These are very state specific. So every state has their own forms for these powers of attorney, especially. A will is going to look pretty similar from state to state. And then a trust is often used to avoid probate. And there is no, asset minimum. I have to have, $10
Sure.
million to have a trust. I'd say that's not the case. Even some basic complexity like a vacation home, you live in Illinois but have a house in Florida, that can dictate having a trust because the trust can hold the title to the assets, and that way you can avoid probate in both those states.
Sure. So getting back to the will, so even if you think like, okay, I'm married, I have 2 children, right? If I don't have a will, everything's going to go to my spouse. You're saying that might not be the case in the sense it's still going to go to your family, but that could prove to be difficult if your spouse was relying on getting all of these assets, but now like part of them went to your children, who may or may not need those assets at this point.
Right. No, that's exactly right. So I think most states say that if you have kids, your assets pass half to your spouse and then half to your
Okay.
children. So definitely having a basic will to avoid that is really useful for a lot of people. And people tend to think that everything goes to the spouse, but that may be because they have assets titled
Sure.
jointly, which would trump the will. So if you've got everything titled jointly, you're okay from a probate perspective, but you may also have a tax issue or another reason why you don't want your assets to go right to your spouse, in a joint setting.
Sure. So getting the will, getting the healthcare power of attorney. So that gives someone the ability, if they're incapacitated, or they give someone else that ability, right, to make medical decisions on their behalf, right? So usually like a spouse would give
Right.
the other spouse or close friend or family member like that ability to do that, right?
Yes.
Yeah.
Yes,
And
that's right.
then
That's almost more important sometimes than the money, right?
sure, right? Because there's
The
always
end of life
cases. There
issues.
was one years ago. It was a woman in Florida, right? Terry Schiavo, who I think for like 15 years,
Right.
her family like had differences of opinion, her parents versus her husband about what she wanted, and they kind of fought over that. So, yeah.
Right.
And then the financial power of attorney, that gives someone, like you said, the ability to make withdrawals or transactions in your behalf, like if you were incapacitated.
Right. So to continue paying your bills, say your mortgage, your utility bills, and if you were taking distributions from an IRA, for example, that person could continue that payment stream. Um, so any type of financial asset that you own, and you can limit the powers in those powers of attorney if there's something, say you have a
Sure.
business, and you want someone from your business to manage your business decisions, you can treat that
Oh, okay.
differently.
I didn't even think of that. Yeah. Yeah, because like you said, if one of my clients, husband and wife I'm working with, one calls me up and says, take money out of the other one's account, and I can't do that unless I talk to that other person or I've got some document allowing me to do that. Yeah.
Right.
Okay. So getting those is important. And then you mentioned too about like titling of assets. So like having things jointly held, I guess that could maybe simplify the probate process a little bit, because like if versus single name, like if your bank account was jointly held with your spouse or someone else, that doesn't generally need to go through probate.
It does simplify the transfer of those assets, having them held jointly, but there can be other issues with it. And a spouse having assets jointly is probably not the best example. But say you're single or your spouse has passed away, and say you have 2 kids and you want to title your assets jointly with your
Sure.
children to avoid probate. That probably isn't the best scenario because if your child has his or her own creditor issues, they can access that money when the child is a joint owner. And say you have your child on your house, now you want to sell your
Yeah.
house or downsize. Your child has to consent. So that doesn't always work. It's fraught with some pitfalls. But for really basic things, it might be okay. And like maybe your checking account,
Sure.
you want some access to quick liquidity for your child or somebody, you could do that where you put someone's name on it. But it's just something you really need an advisor, kind of like yourself, or a team of advisors to kind of help you think through
Yeah.
and make
Maybe
sure
not
you're
everything,
accounting for
but
all situations.
because most people,
Yeah,
right, they pass away, and maybe if they haven't prepaid for, let's say, funeral expenses, and their family couldn't afford to pay for that, but they had a lot of assets. If they didn't have anything that they could access, or the funeral home wouldn't extend them credit, then having something jointly held, I guess, could be helpful. because then if they're on that account, they can then quickly access that usually, right?
Right, that's true. So if there's a joint account, there's some quick liquidity access there. If you have a trust, and you can often get the same quick access to
True.
liquidity, but the will takes a little longer because you've got to go to probate and get someone appointed, and that's where the delay can really come
Yeah.
in.
What about using like transfer on death accounts? Do you think that could be, another idea? And it is, besides the trust, like to also give people quick access, but not access like during, like you said, from, divorce or creditors or things like that.
Yeah, we do see those used sometimes where the person isn't on the account during lifetime, but they are the beneficiary, if you will, when the owner of the account dies. That can be helpful too to get some quick liquidity, but if you try to use those on all your accounts to accomplish estate planning, there are some pitfalls too, like, daughters on one account, sons on a different account, and the dollar values might not match
Sure.
up.
Yeah.
So really, an estate plan can make more
Yeah.
sense.
Yeah. Yeah. So I guess you'd have to figure that out, or maybe put them both on there, or go to the next thing you could do, which I guess would be trust, right? And so tell us a little bit about the trust and what a trust could do for you versus using like, a traditional non-trust estate plan.
Yeah, a trust can really, people tend to think, oh, it's complex and these trusts live on years and years, but that's not always the case. A trust can really function like a will substitute. So your trust can provide immediate access to liquidity in the event of death or incapacity because you've got this written document. It's not governed by a court unless there's a reason to bring it before a court, but the court doesn't need to approve the appointment of a trustee. It's already named in the document. So it gives you that. It also gives you privacy because it doesn't become a public record like a will does. So some people really like that about it. Your will might be very
Sure.
generic, saying all my assets go to my trust, and then the trust says who gets what. So that is a benefit. And then, of course, avoiding probate. So on assets titled in the name of your trust, which can take a little bit of extra work after you sign your trust, you will avoid probate on those assets titled in the trust. So, and a trust can be, 10 pages. It doesn't have to be a 100-page trust with every, nuance in there. So there's really a degree of complexity that we see,
Okay. Now, is this usually,
or varying
yeah,
degrees.
sure. Is this usually a
Yeah.
revocable trust that you're talking about while someone's alive, or is it irrevocable?
So generally, we're talking about revocable trusts when we're talking about avoiding probate. If we're making gifts to beneficiaries or creating longer term trusts for kids or younger
Sure.
kids or generations, then we might use an irrevocable trust, but that's more in the nature of you're giving away the
Sure.
property. The revocable trust, you're keeping control, you're in charge while you're alive. It doesn't create a separate taxpayer or anything like that. So generally they're also called living
Okay.
trusts.
So living trust, revocable trust. So you set that up, and then once you've done that, what are the next steps you need to do with that? You just create it and you're good, or
Once, yeah. You create it, and then you've got to put your assets into the name of the
okay.
trust. So you may have to do some retitling, like deeds to your trust if you've got a house or a vacation house. Um, Most people don't put their checking account or their cars in a trust because those values are low enough that you can still avoid probate. But you may have an investment account or your house, for example. I think I
Yeah.
said that one. So the larger assets would need to be titled in the name of the trust to avoid probate. And that's not a taxable event. It's just some extra paperwork that you want to do up front to sort of save your beneficiaries time on the back end.
Sure. So you've got a brokerage account, right? And so if it was jointly held or even single name, now you create the trust, you reach out to that advisor or that firm, fill out some paperwork. Now your brokerage account's in the name of the trust, right? And then,
Exactly, right. Same social security number, no separate tax ID number, anything like that, no changes to your income tax
and
filings.
you can then add things into it, take things out of it, and then upon your death, now it becomes irrevocable. Is that what happens?
That's right. So upon your death, it can't be changed, but you wouldn't want to change it because the person who created it made their wishes clear, and then it becomes effectuated, by the distribution of the assets, gathering, paying expenses such as funeral costs or whatever there was, maybe some final medical bills, and then distributing the assets. And that can really shorten the process because you don't have that court
Sure.
proceeding.
So I guess it depends on the company. If we're talking like an investment account or bank account, but I'd imagine you probably just provide a death certificate and then fill out whatever paperwork, if any, to like move the account over, or maybe not even, because it's already in the trust.
Right. You might just change the name of the trustee, although usually when someone dies, the trust becomes its own
Oh, okay.
taxpayer. So there isn't a new account often with a new tax ID number because that trust has to file an income tax return for the period after the
Sure.
death of the
Okay.
owner with a little different rules. So there is a little bit of paperwork, but it's much simpler than a court proceeding and no judges involved. So the financial firm may want a copy of the trust, acceptance by the new
Okay.
trustee, maybe a certification of the trust, that's still in
Sure.
existence, it's valid under state law, some things like that.
Well, we're talking probably like weeks or a month, right, to maybe move this over. If you're really in a jam, maybe they could even do it faster if you got all the stuff to them, and then versus months upon months, if not years, that it could take to settle a traditional estate if this was an individually owned asset, right?
Yes, I agree.
Yeah.
Definitely.
So what do you like for retirement accounts? Do you have an opinion on, is it a good idea if you set up one of these trusts, should you name the trust as the beneficiary of your retirement accounts? Or is it a better idea if you have living people that you want to get the assets to name them as the beneficiary?
Yeah, we tend to name the individuals instead of the trust, and that's partly because the IRA is tax deferred. So when those distributions come out, they're taxable. And if we have to flow them through a trust and it's done incorrectly, sometimes we can accelerate the income
Sure.
tax. So for people who have adult beneficiaries, we often just have them name the beneficiary directly, and unless there's a concern about creditors or some other reason why we wouldn't name that person directly. And if people have minor children, then we probably would want to flow it through the trust in a more direct fashion where we name the child, but we direct that it be retained in trust so that the child can withdraw it over a longer
Okay,
period.
that makes sense
Or really
because
the trustee would.
the IRA, if you've got, let's say, $1 million IRA, right, and you name your two children as the beneficiary, they then split that up and they've got a 10-year window now, generally, right, to draw that money out. Versus if you did the
Right.
trust, is it a 5-year window or is it all due in 1 year usually, the taxes?
If you do the trust, you can still create separate shares and have each individual beneficiary treated as are subject to
Oh,
the
okay.
10-year rule generally. So there could be like a trust for my daughter, and that trust is still subject to that 10-year rule. There's some timing requirements about how it has to be divided within 9 months of the person dying. So you have to be a little bit on top of those rules, but you can still use that 10-year stretch, if you will. And actually, I think if you're a minor, it's
Yeah,
longer.
it's still the age of majority, right, in most states, which could be 18 or 21. Um,
And then the 10-year rule
oh, it
applies,
does.
I
Oh,
think.
okay. Interesting. Yeah.
Yeah.
So you mentioned creating the trust like while you're alive. I've heard of something called like trusts that are created through your death, through your will. If you do it that way, are
Mhm.
there pros and cons to that versus creating it while you're alive?
Those, I think you're referring to a testamentary
Yes. Yeah.
trust, and that would be created in a will. So the will, you're still going to have probate. So those trusts can be protective for minor children. For
Okay.
example, if you want to have a will, leave your assets to your minor children, trust can be set up so that the children's money doesn't have to go through a probate proceeding for
Okay.
them. Because if they're under 18, they can't inherit property in their own
Sure.
name. So sometimes you can use a UTMA account or something, but generally, if you create testamentary trust for your kids, you can at least let someone manage that for them through those trusts. But the owner of the accounts is not going to avoid probate because now you're talking about a will.
Sure. Yeah. So it's better, I guess, to do it to set it up. It sounds like while you're alive, if your goal is to avoid probate for the time frame and maybe the cost as well, right? To do it Yeah.
Right, right. And really, a will with trust built into it is almost as complicated as a living trust
Oh, okay.
often, so it may be a
Yeah.
similar cost depending on the attorney you're working
Sure.
with.
In probate, it's usually it's based the probate fees, that is, it's usually based on the size of the estate, right? So the bigger the estate, the more you pay, or
It really varies by state. For example, I think Florida has the kind of rules you're talking about,
okay.
where the attorney and the representative of the estate take a percentage of the assets. But in Illinois, where I am, we charge what's called reasonable compensation, not the attorney, but the
Sure.
executor. And we as lawyers also are subject to the reasonable compensation standard, so we can't charge, 100,000 of fees on a $10,000 estate or something. The court would view that as
Okay.
unreasonable. So there is no statutory fee in some
Because
states.
I've heard like 3 to 5% is what sometimes states could be charged, right? Is that by the probate court or is that by the attorneys?
I think it's by the attorney and or the representative of
Oh,
the
okay.
estate who is entitled to a
Sure.
fee. So if I name somebody as my executor, they can take a fee for the time they're spending
Sure.
doing it. And in some states, that's statutory. But I think you're right that the lawyer's fees is also statutory in certain states. But I think there's a great degree of variety. And I think in Florida, it might go down to 1%, starts at
Okay. All
1%.
right.
So,
But if I guess if you use a trust, right, and you set that up, um, that's gonna, or for a lot of your assets, that's gonna help reduce a lot of that cost, right? Because you're not gonna need that.
right. And you can set the compensation in the trust if you choose to do
Okay.
that.
Like to pay your trustee.
Right.
Okay. Is that is an individual or does that have to be a professional trustee?
No, you can use either. A lot of people use individuals, but if for some reason a corporate trustee is called for, there again, there's a wide variety of fees charged. Like there's some smaller trust companies that will charge maybe less than 1% or 1%, but the bigger trust companies, have more of the sliding scale, probably start at 1 or 2% and then go down
Okay.
depending on how much value there is in the
Okay.
estate.
Interesting. So in
Yeah.
addition to getting your will, getting the financial power of attorney, healthcare power of attorney, possibly a trust, what other things should someone be doing just to simplify the estate planning process for their family?
I think keeping track of their assets is helpful as well. Having records of what they own and how it's titled can be helpful. But if you've got those documents in place, I think that's a really good first step, unless you have a taxable estate or you need to worry about estate tax or income tax, or you've got capital gain
Sure.
assets. But when someone dies, we didn't talk too much about this. Assets are stepped up to their value at the date of death, so any built-in capital gain really goes away in most cases. An IRA, that's going to be subject to the ordinary income rules no matter what. But the investment assets generally get a step up in basis, which is
True.
helpful.
So if you've got some stocks you bought years ago or real estate that has gone up a lot in value, rather than you selling it and paying the capital gains tax, you leave it to your family, and then their cost basis is the value that it was the day they died, right? Um, yes.
Exactly.
So then they
Right.
could turn around and sell it and not have to pay a lot of tax, most likely, if it
Right.
was sold quickly.
Right.
Yeah, I like that
Hmm.
about documenting your
Yeah.
intentions. I have something I came across years ago called a family love letter that I give to clients, recommend they fill out. It's like a 10-page document that lists out, like, help them list out all their accounts, like all their advisors, their liabilities, many other things too, just to like give their family a good record of where everything is.
Hmm. Yeah, I think that is really helpful to have. And sometimes people also might write some sort of side letter about, like, if you do have minor kids and you're concerned about them going to Catholic school, for example, or religious school, I should say, something like that. You might put some of that in more of a letter of
Sure.
wishes kind of thing, depending on your desire. And that isn't technically binding, but it can be helpful for your trustee to kind of have a good feeling for, I want my kids to go to private school, or I want my kids to go to, a 4-year college or whatever it might be.
Sure. Yeah. I think also too, like I was just thinking, as far as your wishes, like what you want upon your death, like, do you want to be buried? Do you want to be cremated? What type of, funeral do you want? Or, where do you want your, grave to be, or ashes to be spread? Right. Sometimes we don't talk about that. And by having all that, like it's just going to make it easier on your family. Less things to think about, like in a difficult time.
Yeah, I totally agree with that. And kids can really get on each other in these situations too. Like mom would have wanted this or would have wanted that. Well, if it's spelled out, like you're saying, that takes all the drama out of that,
Yeah.
right? Because you've set forth what you want and there's no fighting about what to do with the ashes or whether to bury someone. It's
Yeah.
really helpful.
Do you think it's a good idea to prepay for your funeral or your grave stone, or cemetery plot?
I don't see that often, but some people do that. And I think if you want to be buried, it is helpful to have decided
Sure.
where and have those plots at the ready for your executor to make that decision. Um, but it's not a requirement. I think it does make it a little easier on people, but it may depend on kind of how elaborate of a funeral you want
Sure.
to.
Yeah.
Mhm.
So assuming like everyone's done this, right? They follow these steps, they get this stuff set up. How often should they be reviewing, what they've done?
I tell all of my clients to think about it every 3 to 5 years. And really, in our world, I think post COVID, people are moving more, they're on the go. So if I do my estate plan in Illinois and my husband and I move to Florida, or even if we're spending time in
Sure.
multiple states, we may want to get that reviewed, or we may want to have documents like the powers of attorney, for example, in case we got injured in Florida and now we need a Florida power of attorney because they don't like our Illinois form, for
Sure.
example. So I think another trigger is kind of these life events. You move, someone in your family dies. Maybe you named a sibling as executor or trustee, and that person gets divorced and their life changes. That may impact your decision. So there isn't a real hard and fast rule, but I think things can really change in your family. So I think you want to be thinking about, oh, this happened, do I need to change my will?
Sure. Yeah, that makes sense.
Mhm.
So I have a listener question if we have time. So I got this question. It says, my granddaughter lives with me and I still have a mortgage on my home. I have two other adult children. I'd also like to inherit part of my estate. Could I leave my granddaughter my home so that if she outlives me and she still wants to live there, she can live in it? How could that be done? And given there's yeah, I mentioned earlier, given there's a mortgage, I don't know if that makes it more complex, but
Yeah, I think that's a perfect situation for a trust either created at this person's death or a lifetime trust that provides for that, retaining that home and trust. And what you would probably do there is set up a trust that just owns that residence for the granddaughter for her
sure,
benefit, but not her permanent ownership, either for some time period, say he lets her live there for 10 years or a few years after death, and then that house gets sold or just she has to buy it, for example, and the money gets paid to the two children or including the grandchild, however he wants to set it up. But I think that can be done kind of like in a trust format where the granddaughter isn't the true owner of the house. Because if you give her the house, she now has
sure.
control of it. She can sell it and keep the money and doesn't really have an obligation to give it to the children. So a trust would work well for that
Okay.
situation.
Does it complicate things if there's a mortgage on a property when someone passes away and they want to put it into a trust? Does the mortgage have to be satisfied, or will they let the trust like assume the mortgage?
It's a good question. I think a lot of times, generally, it would be required that the mortgage be satisfied. But if it's a shorter time period, the trustee might be able to continue paying the mortgage, keep it in place until the house is eventually disposed of. Probably depends on how long that's going to remain in
Okay.
place. And you would want to put some cash in that trust for the granddaughter so that the trustee has money to pay the mortgage. Because if you leave everything else to the other two kids,
Yeah, there's nothing
someone's got to
there.
pay the
Yeah.
mortgage.
Yeah, that makes sense.
Right,
Awesome.
right.
Um, so, are you taking on new clients? And if you are, like, how would someone reach out to you?
Yeah, I'm in Illinois, like I said, so we work with clients in Illinois, Colorado, in Georgia, and Florida, and we are taking on new clients. You can find me on LinkedIn. My firm's website is harrisonllp.com, so that's www.harrison with SONLLP. And I'm listed on there as one of the attorneys, so you could reach out to me there if you'd like to. And we often do an introductory discussion about whether we can help the client. Are we a good
Sure.
fit? To try to make sure it's the
Yeah.
right thing.
And I'll put a link in the show
Yeah.
notes with Natalie's information as far as her firm and her LinkedIn profile as well. And I'm guessing, like, you work with clients over Zoom as well. Like, if you're working in all those states, you're probably not traveling to all those places, right?
Right. We do some stuff over Zoom, or we might have somebody local that can help
Oh,
too,
okay.
depending on the client's comfort
Awesome.
level. Yeah. Yeah.
Yeah. Is there anything else you want to share before we wrap up this week?
I think it's important to have estate planning, and it doesn't have to be a $10,000 project. So I think try to find somebody that is an expert in the field, even if that's what they do routinely is their skill level, versus somebody who maybe does a little
Sure.
estate planning, a little bit of everything. It's really helpful to have somebody who kind of knows the issues that can
Yeah, that
arise.
makes sense. Awesome.
Yeah.
Well, thank you very, very much for coming on, sharing this information, Natalie. And as always, if anyone has a listener question and you want to have that considered for a future episode, consider going to retirewithryan.com, click on Ask a Question, and we'll consider that for a future episode. Have a great week, and I look forward to talking with you next Wednesday. Take care.